Who and what the FDCPA applies to. Brought to you by YourLegalLegUp.com, your advantage if you're being sued by debt collectors.
Hi, this is Ken Javert at YourLegalLegUp.com, and as you probably know, my website gives ordinary people the help that they need to beat the debt collectors, whether they're in the litigation already or whether they're just leading up, situation is just leading up to possible litigation. We give you what you need to beat the debt collectors and keep you out of hot water. Today we're going to do a brief two-part video on the FDCPA, who it applies to and what actions it applies to. So the first part will be dealing with who it applies to, both from the perspective of the consumer and who it applies to as regards the debt collectors themselves. And then we'll also talk about what kinds of actions come within the FDCPA. In our next videos, we're going to talk about what to do if the FDCPA does apply and you think the other, that the debt collectors aren't abiding by it. And if the FDCPA does not apply to you, there are still some other options that you could consider. In the final video, we'll talk a little bit about those.
As a general rule, the FDCPA only applies to consumer debts and, by and large, the actions of debt collectors. It can apply to original creditors who are pretending to be debt collectors as well, and they do that sometimes to give you the wrong idea that they're taking more aggressive steps than they actually are, by hiring someone else to bug you. So we're looking at the type of debt for which collection is sought and the type of entity seeking the debt, as well as the actions of the person bugging you. The FDCPA applies to consumer debts, or debts incurred primarily for personal, family, or household purposes. When the debt is rung up on a corporate or business credit card, the courts will look at the nature of the debt and not simply at the name on the card. Although, as I've pointed out elsewhere, making this argument can be dangerous to the corporate shield, since it suggests a merging of assets, which might be used to defeat the corporate shield and allow a creditor to pursue an owner of the corporation personally. So beware if that's your situation. It would be possible to go the other way too. If you buy something for your business on a personal credit card, it could be found to be not consumer debt. Because the FDCPA was designed to protect consumers, it only protects natural persons. And that means it only applies to actual people and not corporations or separate associations. The theory there is that businesses are or can be more sophisticated and don't need the protection. Of course, this is often not true in real life, but that's the way the law is designed. Businesses are not protected. Again, since debt collectors never actually speak to corporations or businesses, but only to humans, this simply means that if a debt collector is calling you about a debt rung up by your business and harassing whoever picks up the phone, for example, the FDCPA does not apply. The FDCPA applies to transactions engaged in primarily for personal, family, or household debt. In other words, it does not apply to debts generated by child support obligations, tort claims, that's a lawsuit against you for harming another person, or personal taxes, for example, because these are not transactions. On the other hand, the term transaction can be fairly broad, and it would include things like condominium fees or other fees or debts incurred as part of a transaction that might, in fact, have occurred years before the debt in question arose. Because the FDCPA applies to debts arising out of transactions, it's applied to condo fees for a house the consumer once lived in, but later, at the time of the FDCPA violation, was renting out to others for business purposes or for generating income. The transaction originally was for housing when it was done. This would suggest that the reverse might be true too. A condo originally purchased for business purposes but later converted to personal use might not be covered by the FDCPA, but I haven't seen a case with that holding. The Act does apply to things you might consider non-credit transactions, such as bad check debts, condominium assessment fees, residential rental payments, municipal water and sewer service, and other non-credit consumer obligations. Credit is not a necessary part of the FDCPA. In our next video, we'll discuss the people on the other side of the issue, the debt collectors and acts of debt collection that come under the FDCPA. Protect what's yours and don't let the debt collectors rip you off. yourlegalega.com